All rise, vous vous levez. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte.
Good afternoon to everyone. Please be seated. The hearing on the initial appearance is now in session. I would like to welcome everyone who is here today in the courtroom. Mr. Ongwen, good afternoon and welcome to this hearing. I also greet the prosecutor and her team, and also the Duty Counsel for Mr. Ongwen. Also, I welcome the registrar and his team. I would extend my welcome also to the interpreters, to the court reporters, to the courtroom staff behind the scene, offering IT and audio-visual support, and the security officers, all of whom are diligently assisting us all in our work. Finally, I greet those in the public gallery and outside the court who join us here this afternoon. Before we resort to the actual subject matter of the initial hearing today, I would like to recall that the Chamber has authorized video recording and taking of photographs for 1.5 minutes, no longer. Accordingly, I will ask the court officer to please usher the photographers and cameramen, if any, into the courtroom. Thank you. You have 1.5 minutes to do your job. Please proceed. You may leave the courtroom. Good afternoon. At this point, I would like to invite the parties and the registrar to introduce themselves, beginning, as always in the proceedings before the ICC, with the Office of the Prosecutor. For the record, I ask you, Madam Prosecutor, to introduce yourself and the members of your team who are joining you today.
Thank you, Madam President. Madam President, the Office of the Prosecutor is represented this afternoon by Mr. James Stewart, Deputy Prosecutor, Ben Gumpert, Senior Trial Lawyer, Pakiso Mochochoko, Director of Jurisdiction, Complementarity and Cooperation Division, Diane Looping, Trial Lawyer, Pubudu Sachitan Nandan, Trial Lawyer, Kamran Chowdhury, International Cooperation Advisor, and Douglas Grieve, Acting Case Manager. Thank you.
Thank you very much, Madam Prosecutor. Now I turn to the Duty Counsel for Mr. Ongwen. You are invited to take the floor and to present yourself to the court, and I do not see that you are joined by members of your team.
Thank you, Madam President. I shall speak in English in order to facilitate a direct translation into Acholi for Mr. Dominic Ongwen.
Thank you.
I am Mrs. Hélène Cisse from the Bar of Senegal since 1982. And I am also an ICC counsel practicing in some cases under the jurisdiction of this court since 2009. And I am standing in this courtroom today for the defense of Mr. Dominic Ongwen as in my capacity of Duty Counsel, and it's a great honor for me. Thank you.
Thank you very much, Ms. Cisse. Now, Mr. Registrar, it's your turn.
Thank you, Your Honor. Herman van Ebel, the Registrar, and with me, Marc Dubuisson, Director of Court Services. Thank you.
Thank you very much. Finally, I have to introduce myself and the legal support staff in this case. My name is Ekaterina Trendafilova. I'm the presiding judge of Pretrial Chamber 2, and also the single judge in this case, as designated by the full chamber with a decision of 21st January 2015. I will exercise all functions of the pretrial chamber, with the exceptions of those functions that are mandatorily under the statutory provisions to be taken by the full chamber. And this is provided in Article 57, paragraph 2A of the Rome Statute. The other two members of Pretrial Chamber 2 are Judges Kuno Tarfurser and Christine van den Weingert, who are not present in the courtroom today. To my left, seated are the Senior Legal Advisor of the Pretrial Division, Mr. Gilbert Biti, and Legal Officer Mohamed El Zaidi. Further to my left is Legal Officer Eleni Haitidou and Associate Legal Officer Nicolo Pons. Also in the courtroom are Manon Henis and Laura Similovsky, the interns of the Pretrial Division. Now I turn to the suspect, Mr. Ongwen. Mr. Ongwen, please stand up and identify yourself to the court. In particular, I invite you to tell us your full name, your date and place of birth, and finally, your current profession. I would ask you to please speak slowly, as to allow the interpreters to do their job, to translate. Switch on your microphone before you speak. The floor is over to you. What is your full name, date and place of birth, and current profession?
Thank you. First of all, I would like to thank God for creating heaven and earth, together with everybody that's on earth. My name is Dominic Ongwen, YY. I'm a Ugandan citizen from northern Uganda. I'm from Gulu in northern Uganda, in Amura district, Kilak County, a small place called Rome. I was born in 1975. I was abducted in 1988, and I was taken to the bush when I was 14 years old. Up till now, I'm before you, present at the ICC, and I'd like to thank you very much to meet you, to see you and to meet you at this time. Since my arrival, I've been informed that I've been brought to the ICC because of crimes.
Mr. Ongwen, now my question is limited just to what you have already informed the chamber, apart from if you can tell me what is your current profession.
Right now, I'm unemployed. And that's all.
You appeared before the court? If give me this information.
Prior to my arrival at the court, I was a soldier in the LRA.
Be seated, Mr. Ongwen.
Thank you.
At this point, I have to address the issue of your language proficiency, Mr. Ongwen. The Chamber has already received a report from the registry last Friday indicating your language proficiency. Still, during this initial appearance, I have to hear from you personally, Mr. Ongwen, whether you fully understand and speak either of the two working languages of this court, French or English, or any other language, and which is that language. Although we have already heard your answers, thanks to the support of an interpreter, but I need to hear from you as well. What is the language that you fully understand and speak? Mr. Ongwen, would you respond to this question?
The language I'm proficient in is Luo, and that is Acholi.
You may be seated. Again, from the report of the registrar from last Friday, the Chamber was informed that you have been provided with the services of an Acholi interpreter who is obviously assisting us today during this hearing. I would like to thank the registrar for making these arrangements because these arrangements are vital to one of the fundamental rights provided to Mr. Ongwen by virtue of Article 67, paragraph 1a, consistent with international human rights standards. And I'm fully satisfied now, duly satisfied, that this right of the suspect is safeguarded. The only point that I would like to make that language arrangements should be sustained, these language arrangements, for the whole duration of the proceedings before the court, so that the requirements of fairness of the proceedings are met. Having dispensed with the necessary preliminary matters, I will shortly explain the nature and the purpose of the initial appearance, which is meant to be informative for Mr. Ongwen and also for everyone in attendance today in and outside the courtroom. Elucidating the nature and purpose of today's hearing should also serve another objective, and it is to guide the parties to strictly adhere to the subject matter of the initial appearance and to refrain from engaging in issues which are extraneous to it. I have a question to the interpreter. Do I speak sufficiently slow as to allow the interpreter to do his or her job?
You do, Your Honor.
Thank you. In particular, for Mr. Ongwen, who is not familiar with the procedure established under the Rome Statute, I should underline that the initial appearance is neither a trial nor a confirmation hearing. No evidence will be presented or collected today, nor will the issue of guilt or innocence be addressed, contemplated, or decided upon. The nature and purpose of today's hearing is governed by two provisions, two statutory provisions, namely Article 60, paragraph 1 of the Rome Statute and Rule 121, paragraph 1 of the Rules of Procedure and Evidence, which delineate the limited scope of the initial appearance. Thus, today the Chamber must satisfy itself that, first, you, Mr. Ongwen, are informed of the crimes which you are alleged to have committed. Second, that you are also informed of your rights under the statutory documents of the International Criminal Court. And finally, the pretrial chamber must set up the date on which it intends to hold the confirmation of charges hearing, pursuant to which the pretrial chamber in its full composition is going either to confirm or to decline to confirm the charges brought against you in the case pending before pretrial chamber 2. Therefore, now I will proceed consecutively with the three issues shaping the subject matter of today's initial appearance. First, this is the knowledge of the charges, of the counts that Mr. Ongwen has to be informed about. I would like to ask the court officer at this juncture to read out the counts as presented in the public redacted version of the warrant of arrest against Mr. Ongwen, which was issued on the 8th of July 2005.
Thank you, Your Honor. Pursuant to the public redacted version of the warrant of arrest, registered as ICC 0204-010557, dated 8 July 2005, Pretrial Chamber 2 concluded that there are reasonable grounds to believe that Mr. Dominic Ongwen, together with other persons whose arrests are sought by the prosecutor, ordered the commission of crimes within the jurisdiction of the court, namely crimes against humanity and war crimes, particulars of which are set out in the following counts. First count. In 2004, Mr. Ongwen ordered the commission of murder as a crime against humanity, which in fact occurred, namely the unlawful killings of civilian residents of IDP camp in Uganda, pursuant to Articles 7.1a and 25.3b of the statute. Second count. In 2004, Mr. Ongwen ordered the commission of enslavement as a crime against humanity which in fact occurred, namely the enslavement of civilian residents of IDP camp in Uganda, pursuant to Articles 7.1c and 25.3b of the statute.
Court officer, be asked to slow down, please.
Sorry, court officer, would you slow down, please? Yes, this is a request from the booth.
So I repeat the third count. In 2004, Mr. Ongwen ordered the commission of inhumane acts as a crime against humanity, which in fact occurred, namely the inhuman acts of inflicting serious bodily injury and suffering upon civilian residents of IDP camp in Uganda, pursuant to Articles 7.1k and 25.3b of the statute. Fourth count. In 2004, Mr. Ongwen ordered the commission of murder as a war crime, which in fact occurred, namely the killings of civilian residents of IDP camp in Uganda, pursuant to Articles 8.2ci and 25.3b of the statute. Fifth count. In 2004, Mr. Ongwen ordered the commission of cruel treatment as a war crime which in fact occurred, namely the cruel treatment of civilian residents of IDP camp in Uganda, pursuant to Articles 8.2ci and 25.3b of the statute. Sixth count. In 2004, Mr. Ongwen ordered the commission of attack against the civilian population as a war crime which in fact occurred, namely the intentional directing of attacks against the civilian population of IDP camp and against individual civilians not taking direct part in hostilities in Uganda pursuant to Articles 8, 2, EI and 25, 3B of the statute. And finally, the seventh count. In 2004, Mr. Ongwen ordered the commission of pillaging as a war crime, which in fact occurred, namely the pillaging of IDP camp in Uganda, pursuant to Articles 8, 2, E5 and 25, 3B of the statute.
Thank you, Court Officer. You may be seated. Before I proceed further, I should clarify to Mr. Ongwen and to his defense lawyer that the counts read out right now are those appearing in the warrant of arrest provided to Mr. Ongwen and his defense counsel, numbered as count 27, 28, 29, 30, 31, 32, and 33. This is the order of the counts presented in the prosecutor's application to the pretrial chamber for issuing warrants of arrest. After this clarification on my part, I would like to ask Mr. Ongwen whether he has been informed of the crimes set out in the warrants of arrest, which according to the prosecutor, he has allegedly committed. But before that, I will still refer and recall some information that is available to the chamber in this regard. And on that basis, I would like to hear from you your answer. Again, I'm going to refer to the very useful report prepared by the registrar and his team from last Friday, according to which Mr. Ongwen has been provided with the warrant of arrest in two languages, in Acholi and English language, and you had sufficient time to acquaint yourself with the content of the arrest warrant for the limited purpose of today's hearing. In addition, the registrar again has appointed Madame Cisse as defense counsel, who has been assigned to assist Mr. Ongwen before and during today's initial appearance, which in my view suggests that she has been providing clarification concerning the counts contained in the arrest warrant against Mr. Ongwen, of course to the extent necessary for the purposes of today's hearing. Having provided the information to the defense of Mr. Ongwen and to Mr. Ongwen himself, which is available to the chamber before this hearing, I would still ask Mr. Ongwen to take the floor and personally, in this public initial appearance hearing, to state whether he has been informed of the crimes that he is alleged to have committed. Mr. Ongwen, would you please take the floor? Have you crimes you are
I have been informed.
Thank you very much. This suffices for the moment. Now I come to the second issue that falls within the scope of today's initial appearance, actually the issue of whether the suspect has knowledge of the rights that are accorded to any suspect before the International Criminal Court. Before I hand over the floor to Mr. Ongwen, I will again refer to the report of the registry, whereby an important information has been provided to the Chamber, namely that you, Mr. Ongwen, signed a declaration confirming your consent to voluntarily appear before the International Criminal Court, and you were transferred to the custody of the court on Friday, 16th of January 2015, in Bangui, Central African Republic, where you met in the presence of Ms. Hélène Cisse, representatives of the registrar. They provided you with the warrant of arrest together with its annex, which contains all rights accorded to you as a suspect before this institution by the Rome Statute, the Rules of Procedure and Evidence. Second, you met again with representatives of the registrar upon your arrival at the detention center in The Hague, and you were informed again, with the assistance of an Acholi interpreter, of your rights granted by the Rome Statute and other statutory documents. In regard of your rights, I will refer to the meetings that you had with Ms. Cisse in Bangui and here in The Hague. Thus, it is assumed that in these meetings, the issues that we are discussing today have been addressed, and in particular, the rights you enjoy as a suspect before the ICC. Regardless of this information, I will still need your personal answer during this public initial appearance hearing, whether you have knowledge of the rights that you are granted as suspect in the proceedings before the International Criminal Court. What is your answer to this question, Mr. Ongwen?
I have been informed of all my rights. Correctly, I am informed.
Be seated. Notwithstanding this answer, I seize this moment to recall at the initial appearance, albeit not exhaustively, your rights, which are central to the conduct of the proceedings before the International Criminal Court. The statutory regime of this court, in accordance and consistent with internationally recognized human rights, afford the suspect the following rights. Mr. Ongwen, you will be presumed innocent until proven guilty beyond reasonable doubt at trial, with the burden firmly placed on the prosecutor to prove your guilt. In line with this right, there cannot be a reversal of the burden of proof or any onus of rebuttal. Next, you have the right to be informed promptly and in detail of the nature, cause, and content of the charges in a language which you fully understand and speak, which in this case I understand is Luo or Acholi, as you clarified. This is an obligation entrusted on the court, which has already been triggered as soon as you came into the custody of the court. Next, you will have adequate time and facilities for the preparation of your defense. Also, you have the right to receive material which shows or tends to show your innocence or to mitigate your guilt, or also which may affect the credibility of incriminating evidence. You may put questions to and examine witnesses. This duly applies to the confirmation of charges hearing if the parties would request and the chamber will agree to have the presence of live witnesses. You may make also unsworn oral and written statements in your defense. You have the right to be tried without undue delay. You also have the right at the confirmation of charges hearing to object to the charges, to challenge the evidence presented by the prosecutor, and to present evidence yourself. There will be no trial in case the charges are not confirmed, and the proceedings before the International Criminal Court will be terminated. You are entitled to waive your right to be present at the hearing on the confirmation of charges. Rule 124, paragraph 1 dictates. However, you should be mindful that the chamber can order you to appear if it considers necessary and decides to hold the hearing in your absence, that it cannot hold the hearing in your absence. This is what Rule 125, paragraph 4 dictates. Similarly, you are entitled to waive your right to participate in status conferences. You also have the right to apply for interim release as provided by Article 60 and Rule 118, paragraph 1 of the Rules of Procedure and Evidence. You have the right to appeal certain decisions in accordance with the statute and the relevant rules of procedure and evidence. And you also have the right to choose your own counsel. That might be Ms. Cisse or anyone else, and this is a decision to be taken by the registrar, not by the chamber. The full chamber, and in my capacity as single judge in this case, will constantly monitor the proper conduct of the proceedings and the discharge of duties central for safeguarding the rights of the suspect. Finally, being satisfied that Mr. Ongwen has been informed of the crimes he is alleged to have committed and of his rights, as provided by the statutory documents of the International Criminal Court, I come to the third and last issue on our agenda, namely, setting the date for the confirmation of charges hearing. The judges of this chamber have considered the appropriate date to be set for the commencement of the confirmation hearing, taking into account a number of factors, so that the proceedings unfold efficiently and with due respect for the rights of the suspect. I will refer just to some of these factors. First and foremost, I should recall that this is the first and oldest case before the International Criminal Court. In this regard, it is useful to recall some major procedural developments relevant in the current case. It was on the 16th of December 2003 when the Republic of Uganda, with a letter of referral, seized the International Criminal Court with the, and I quote, situation concerning the Lord's Resistance Army, quotation closed, in northern and western Uganda. Following an investigation conducted by the Office of the Prosecutor of the International Criminal Court applied to the pretrial chamber for the issuance of warrants of arrest against 5 leaders of the Lord's Resistance Army, including Mr. Dominic Ongwen. This application was made on the 6th of May 2005. Having analyzed the prosecutor's application and related material in light of the conditions that have to be satisfied, all of them or one of them, under Article 58 of the Rome Statute, On the 8th of July 2005, the same year, Pretrial Chamber 2 issued a warrant of arrest against Mr. Dominic Ongwen. Thus, since the issuance of this arrest warrant, almost 10 years have elapsed. Obviously, this factor will require some period of time for the parties, in particular for the prosecutor, to organize her office according to these new developments and to prepare for the confirmation of charges hearing. The Chamber is mindful that the defense for Mr. Ongwen will also need time to properly prepare so that it best serves the interests of its client. However, the judges have equally taken heed of the right of Mr. Ongwen to be tried without undue delay, and also of the reasonable time standard as provided for by international human rights documents, which are reflected throughout all statutory documents of this institution. Accordingly, balancing these two major factors in the case at hand, the Chamber has decided that provisionally 24th August 2015 is the date for the commencement of the confirmation hearing. Certainly, depending on the developments of the proceedings, this date may be changed as provided for in Rule 121, paragraph 7. This could be done by the pretrial chamber upon request of either party or both parties, or proprio motu on the motion of the pretrial chamber itself. So, do the parties want to make some comments on this provisional date, the 24th of August 2015, or at this point in time it suffices? Madam Prosecutor.
No, Madam President. No comments.
Thank you very much. Madam Cisse.
Well, I think that the date is good enough for us. As also we refer to the case of Nataganda, where there are similar circumstances, and you gave about 6 months, so I think 7 months. And the parties, the defense will have the possibility to file a submission in case there is other needs. So I think it's okay for us, Madam.
Thank you, Counsel. Before concluding the present hearing, I can proceed with some other organizational matters.
Madam President, I'm sorry. I would like very respectfully, before you decide to close this initial appearance hearing,
Could I ask you to give you the floor before I close the hearing?
Okay, sorry.
Okay. I would like to inform the parties at this point in time of the way the Chamber envisages to organize the steps to follow. First, the Chamber recalls that pursuant to Rule 121, paragraph 2b of the Rules of Procedure and Evidence, the pretrial chamber, represented by the single judge, shall hold status conferences to ensure that disclosure takes place under satisfactory conditions in a transparent, efficient, and expeditious manner. Such status conferences could be scheduled by the single judge, again upon my own initiative, or upon request by the parties. In the decision for this initial appearance, I have already decided to convene a status conference with the prosecutor the day after tomorrow, Wednesday, the 28th of January 2015, only in the presence of the prosecutor, in order to discuss some disclosure issues, evidence issues, and mainly protective issues. The team of the prosecutor has already been invited in the pretrial courtroom, and I will kindly ask the registrar to make arrangements for this status conference. Of course, this doesn't mean that the chamber and the single judge, myself, is not going to conduct such status conferences, if need be, by the defense upon my own suggestion or upon the request of Ms. Cisse or any other counsel if she is not to be extended for the whole duration of the proceedings. So the parties will be ready to respond to decisions of the chamber convening status conferences for different issues that need expeditiously to be resolved. Further, I would like to inform the parties that in due course, after this initial appearance, I will issue a set of decisions governing the proceedings that follow in order to ensure that they unfold properly and expeditiously. More specifically, I can refer to the following decisions. Decision on the modalities and procedure for evidence disclosure. Second decision establishing calendar for evidence disclosure between the parties. Thereafter, the evidence to be communicated to the chamber. Also, in order to organize a smooth, properly organized disclosure, a decision on the principles for redactions will also be prepared in case the prosecutor or the defense will approach the chamber with requests for redactions that the chamber has to authorize to the evidence. And decision also on victims' participation will follow in due course. Lastly, I also wish to inform Mr. Ongwen that the chamber is taking steps to make sure that you will receive the prosecutor's application for arrest warrant and supporting material as soon as possible. And in this regard, it will be important also to inform everyone who, the parties mainly, and everyone who is interested in the proceedings in this case, that we have already started reviewing all 419 documents contained in the case record in order to decide whether some document should be reclassified, and will issue the single judge or the chamber accordingly decisions in this regard. Still, for clarity purposes, of course, I would like to state that the defense for Mr. Ongwen, of course, has access to public documents, but this morning the CMS has been ordered, instructed to provide access to the case record to Ms. Cisse, to confidential documents, and if there are some confidential ex parte, defense only. So this was the additional information that I wanted to provide to the parties and to everyone else interested in these proceedings. The chamber will do its best to do its proper job so that the proceedings run smoothly and in due course. And on any issue that the parties need a judicial determination, please do not hesitate to approach me. Now, Ms. Cisse, you can address any issue you would like to the chamber.
Thank you, Madam President. I just want to underline the fact that the English of Mr. Ongwen is just less than basic. He has been abducted on the eve of his 14th year and denied of any access to education, forced to stay more than 20 years in the bush. So it's very important, and he is willing to examine carefully all the files, the proceedings and evidence, and therefore it's crucial for him to get as soon as possible, as he is entitled to do it according to the Rome Statute and other rules, to get as soon as possible translation into Acholi of all documents of proceedings and evidence, and especially declaration of witness, if possible, in Acholi audio transcription. But he can only start to prepare his defense after receiving these documents. So it's very important that the registry could take steps in order to start enabling Mr. Ongwen to have access in Acholi to all these documents. Thank you, Madam President.
Thank you, Ms. Cisse. This chamber has established its approach to the interpretation of the relevant statutory provisions that you're referring to, and I'm going to issue a decision in this regard quite soon. And you will see that the court documents and piece of evidence in principle are translated, and we are going to discuss this issue because these are the vital rights of Mr. Ongwen. Whether absolutely everything will be translated is an issue on which I'm going to decide. So are there some other issues to be raised by the parties or by the registrar? No, then I would like to thank the parties, the registrar and his team. I would like also to thank, as always, the interpreters, the court officers, the court reporters, the security officers, the court staff. Also, I would like to thank Mr. Ongwen for his respectful behavior. And on this, I pronounce the hearing on the initial appearance of Mr. Dominic Ongwen closed.
All rise, vous vous levez.